Afternoon, everyone. Today, I just want to add on the interstate succession, which I'd already dealt with. However, there was an issue when it came to life partnership. I only dealt with the part where a will was available. In this case, it's a case where there is no will. This was a case that came to Concord, and it came in 2006. The parties were Gori versus Volkova. I might pronounce the surname wrong, bear with me. Whereby this is where the Constitutional Court set the legal precedent that same-sex life partners are entitled to inherit in terms of the Interstate Succession Act 81 of 1987, provided that there is proof that they shared a reciprocal duty of support during their relationship. Please bear in mind, you need to prove a reciprocal duty of support during your relationship between you and the deceased person. So that is the most important thing that people need to bear in mind. And then the Concord mentioned in its judgment that opposite sex life partners had the Marriage Act 25 of 1961 available to them should they wish to solemnize their union, whereas during the subsistence of the applicant's same-sex partnership, no similar legislation was in place. The Civil Union Act 17 of 2006, which allowed same-sex marriages, was only promulgated on the 30th of November 2006. The legal position concerning the opposite sex life partners remained undecided, and it was a matter of time before the courts would decide on this pertinent issue. That is what the article is saying. However, a case came, that of Bwanya versus Master of the High Court. The applicant was Miss Jane Banya, Miss Bwanya, I can't pronounce the surname, approached the Western Cape High Court claiming that she should be considered to be the surviving spouse of the late Mr. Anthony in terms of the Interstate Act and the Maintenance of Surviving Spouse Act. And the late Mr. Anthony had executed a valid will nominating his mother as his sole heir. However, his mother had predeceased him, which left his estate intestate. And why do they say estate intestate when prior there was a beneficiary? It's because the mother, who was the only person that was going to inherit from his estate, had already passed on. So there was no one to inherit because only the mother was the one that was going to be the heir or the person inheriting the assets from the estate of Mr. Anthony. So now Miss Jane then presented evidence that she and the late Mr. Anthony were in a committed life partnership where there was reciprocal support, both financially and emotionally. Can you see? She brought this application and she made sure that she mentions that there was a reciprocal support, both financially and emotionally. And that commencement of lobola negotiations would have taken place had Mr. Anthony not unexpectedly passed away. I'm going to steal somebody's joke where he was saying, when you stay in Sandton, when you die, you don't die, you passed away. However, when you die in Baragwana, we say you've died. I don't know what's the difference, but it said it sounds much better when you say in an elite suburb, people don't die, they pass away. Let me come back to the article itself, and then however, the High Court rejected Ms. Jane's claim on the basis that the definition of spouse referred to in the aforementioned acts pertaining to parties in legally recognized marriages. Consequently, Ms. Jane approached the Constitutional Court challenging the validity and the constitutionality of the definition of a spouse in both of those acts. The applicant sought to have the definition of spouse in the Interstate Succession Act amended, arguing that the existing definition unfairly discriminated against her and the opposite sex life partners on the grounds of gender, marital status, and sexual orientation. So the Constitutional Court held that the exclusion of opposite sex life partners from inheriting under the Interstate Succession Act and claiming maintenance under the Maintenance of Surviving Spouse Act was unjustified discrimination and unconstitutional. And therefore that meant the definition needed to include that of the life partners, because if it's not included, then it means it is unconstitutional. Sorry about that. So people need to know now that all marriages, surviving spouse, they are entitled to inherit from their deceased spouses in an interstate succession, whether it's life partnership, whether it's same-sex partnership, which is marriage, it's life partnership, whether it's customary marriage, whether it's civil marriage, all surviving spouses are entitled to inherit from their partners. As families, especially, I'm going to talk about our own Black communities when the other party or spouse passes on, then the family members, they come in and they make it very uncomfortable for the surviving spouse. And they will come and say, no, there was never a marriage, and now you can see that we've got a Concord judgment whereby all of us, we need to abide with the court decision. That is why it said the Concord set a precedent. A precedent, it means the High Court, the lower courts, they need to follow that decision when they are dealing with matters of life partnership or spouses, surviving spouses, whether it comes to spousal maintenance or just to inherit. Now, this we need to understand as a Black community. I know even in white communities, they do have similar cases whereby the family are not happy with the surviving spouse. So we need to accept and deal with it. Thank you very much for watching this channel, and I still ask you to subscribe, to like, to comment, to challenge. Have a wonderful day. See you next time. Bye.